Okay, we're gonna be live in 40 seconds.
Okay.
Okay, we are live.
Hi, good afternoon. My name is Sarah Austin, and I am a senior attorney in Atlanta Legal Aid's DeKalb County office. My office is a general law unit, which means we do a little of everything, but I am a family law attorney for the most part. That's most of what my practice is. Before we get started today and talk about Georgia legitimation and paternity law, I want to give some quick disclaimers. First of all, this is intended as general legal information. If you have a case that is pending or a case you would like to file, this is not information specific to your case. We always recommend that you speak to a lawyer about the specifics of your case. And our work here today doesn't provide an attorney-client relationship with anyone who's watching today or who watches this on our Facebook page in the future. To create a lawyer-client relationship, you would have to sign a retainer agreement with Atlanta Legal Aid or a different lawyer. The last disclaimer I'd like to give is that I am only licensed to practice law here in Georgia. And so what I'm going to be talking about today is Georgia law. I'll allude a little bit to how it differs from other states' laws, but I'm only qualified to speak on Georgia law. If you are located in another state or have a case in another state, this may or may not be applicable, and you should speak to someone who's licensed there. So what we're going to be talking about today is legitimation and legal parenthood and paternity here in Georgia. Um, every state has their own laws, of course, but Georgia is a bit of an outlier in this area because we are one of only a few states that have a process called legitimation. In many other states, if a mother and father are unmarried and conceive a child, and the child is born and the father's name is put on the birth certificate, then that person has parental rights and is a full legal parent, the same as the mother. Georgia is different from that. Georgia does not do it that way. In Georgia, if you are unmarried and you have a child, a man and a woman have a child together, the mother is the only legal parent at this time, unless and until the father goes through a process called legitimation or otherwise becomes a legitimate father. And we'll talk about the different ways that a father can do that moving forward today. But the main thing to know is that if you are unmarried as a woman and you give birth to a child, you are that child's only legal parent. That applies even if the father's name is on the birth certificate. It applies even if the father's surname is given to the baby. It applies even if the father is ordered to pay child support. Those things do not interact with it. He is still not a legal parent unless and until he goes through one of the ways that you can become a legitimate legal parent in Georgia. Um, and there's three major ways that this can happen, only two of which are still really available. Um, but before we get to those, I just want to clarify that, for purposes of legitimation or who is a legal legitimate parent, if a mother is married at the time a child is conceived or born, then that person is legally presumed to be the child's father. If you're married and you have a child, then both parents have parental rights from day one, from the time the child was born. This gets complicated because sometimes people are married and they, you know, conceive a child with someone who is not their spouse. And that gets into a lot more details than we'll be able to go into today, but we'll talk about it a little bit, what happens if you are that father from outside of marriage. But in the most, common scenario, you have two people who conceive a child together. The child is born, the parents are still unmarried. And then from that standpoint, the father then has three options, or historically has had three options for how they can become the legitimate parent. The first is that if they get legally married, if the mother and father of a child get married after that child is born and he is the biological father, then he is legitimated by the marriage and he becomes that child's legal parent. They don't need to do anything further beyond that legal marriage. The other option is now obsolete, but I want to talk about it because sometimes it comes up. Until 2016 in Georgia, you could do a process called administrative legitimation. an administrative legitimation, you would fill out paperwork in the hospital that both the mother and the father would sign before a notary, saying that they want the father to be legally acknowledged as the child's legal parent, and have all the rights and responsibilities of a legal parent. Now, this is different from the birth certificate, and anyone who's had a baby knows you do a lot of paperwork when you're in the hospital. So a lot of people did this and maybe didn't remember that they did it, or records were not well kept. And it did not seem like there was any sort of central record of who had legitimated children through this process up through 2016. So in many cases, unless people had kept the paperwork, they didn't know for sure if this had happened or not. And then in 2016, that process was phased out. And so after 2016, administrative legitimation, where you could fill out the paperwork in the hospital and not have to go through the courts, was no longer an option. So unless you have a child who's, roughly 8 years old or more, you can be pretty confident that this is not in the mix, but it is sometimes in the mix for children born before or in 2016. So since 2016, other than marrying the mother, the only way that a father can legitimate their child and gain parental rights and parental standing is by filing a legitimation case in the court. That is what establishes their rights and standing as a legal parent to that child. Now, one important thing to know is that legitimation and custody are two separate issues. Legitimation in and of itself does not create a right to custody. So it's possible to get a court order that legitimates your relationship with your child, saying, yes, you are their legal parent, but it still doesn't say between the mother and the father who is entitled to custody of that child, who has the right to care for them, who has the right to make legal decisions for them. Now, it's very common for fathers to file a legitimation case and then a custody action at the same time in the same action, but they do have to be requested as two separate steps. You have to go through the legitimation, jump through that hoop first, and then you have the standing before the court to ask for custody or visitation because you are a legal parent. So if you're talking about judicial legitimation, which is legitimation through the court system, the first step you want to take, and I'm approaching this from the standpoint of a father wanting to legitimate. We'll talk soon about what the mother's options are. If you are the father of a child who was born and you are not married to that child's mother, and you want to obtain parental rights to that child, you're going to need to file a court case to be named as the legitimate father of that child. The document you'll fill out is called a petition for legitimation or complaint for legitimation. And I'll talk a little later on about where you can get sample forms for that. We do have them available through some of Legal Aid's resources. So you're going to get that paperwork, the complaint or petition for legitimation, and fill it out with information about who you are, the father, who is that child's mother, what is the child's name and sex and birth date, or birth year rather. We actually only put the year. And you're going to need to provide the court with information on how you will serve that mother with notice of the legitimation. Because like any other court case, you have to provide notice to the other side when you file the case. Now, in many cases, you'll have unmarried parents who either are in a relationship and co-parenting together, just are not legally married, or even parents who are not romantically together, but who are amicably co-parenting and have a good relationship. And in those cases, the parents may both consent to the case. It may be a situation where you're not worried that the mother is going to respond badly. You know she's on board with this. In situations like that, it may be possible to serve notice on the mother by having her sign an acknowledgement of service. That's just paperwork that she signs saying, yes, I've received the petition for legitimation. I know what it says. I don't need to be formally served by the sheriff or a process server. And that's the case in any kind of court case. You have the option of the other side can sign something acknowledging service rather than having to be served by the sheriff. The other options in that case, or in having someone served, are you can have it sent to the sheriff in the county where you file the case or the county where that person lives. And the sheriff's office will serve it on them. You can hire a private process server who is someone whose job is to find people and serve documents on them. And that's an option if you have someone who's trying to avoid being served. Or, and we'll get to more detail about this later, you can file for service by publication, which is what you do when you've made a good faith effort to find someone and you can't locate them and you need to provide them legal service or legal notice of something somehow. There's the procedure where you file that notice by publishing a notice in the newspaper. So that's how you're going to provide notice to the mother of the child if you are a father seeking legitimation. Let's talk about where you're going to file your divorce or your legitimation case. So the general rule is that you will need to file in the county where the other party lives, not where you live. So that means that if you are, if you're living in Fulton County, but your child's mother lives in DeKalb County, you want to file it here. If the child's mother and you live in the same county, then that simplifies matters. In some cases, people will agree to which of the two counties. If you have two people who live in different counties and one of them will consent to the case being heard in the other person's county, you can get them to sign their consent to the venue. But the general rule is that it's going to need to be filed, in the county where the other person lives, the person you're filing it against. So the steps to filing that legitimation, you fill out the paperwork. You generally are going to need to have some of that notarized, so sign it before a notary, swearing that everything's accurate to the best of your knowledge. And then you will file the paperwork in the Superior Court of the county where the mother lives. And then at that point, either have it served by the sheriff or process server, or see if the mother is willing to sign something acknowledging service, saying that they've received the paperwork and don't need to have it formally served on them. Once the mother is served by whatever form, whether that's an acknowledgement or in-person service, they are given 30 days to file an answer to the legitimation. Now, the answer in any civil lawsuit is the other side's opportunity to respond. And so when a mother is served with a legitimation, she can respond to the court and say, first of all, does she agree that this person is the biological father of the child? Or is she asking the court to order a paternity test? Either a mother or a father can request a paternity test as part of a legitimation. Many times fathers will ask for one because they want to be sure before they go through these steps and form a legal relationship to the child. Sometimes the mother will ask for one because they may want to confirm for sure that this is the biological father. And sometimes a judge will order one, even if neither parent feels the need for a paternity test. The law does not require a paternity test if neither parent is looking for one, but some judges, just as a matter of procedure, always ask for one. So that is a possibility that the court could ask you to undergo a paternity test, or if either side requests one, the court is likely to award one or to order one. And if that happens, generally they'll give a time frame and say, you need to go to a paternity testing facility by such and such date within 30 days, say, and complete the process. And there are many low-cost labs around most areas where you can get that done. So once the case is filed and served, 30 days may pass and the mother has the right to file an answer. In many cases, the person who's served with the legitimation, the mother will often file a counterclaim, which may be for child custody. She may be counterclaiming to say, yes, I agree that you are this child's father. It's fine that you be made their legal parent and have legal standing as their parent, but I want to be established as their legal custodian. They may counterclaim for child support. So that's something to keep in mind. If you have a situation where you're the father of a child and you have not legitimated them and you have not formally been ordered to pay child support, When you file a legitimation, very often the response from the other side is that they say, well, we also want to establish child support. So that's something to be aware of. As I said before, if you are filing a legitimation, the legitimation itself does not give you a right to custody of the child or a visitation schedule with the child, but many times people file those as a all one action. So you'll file a petition for legitimation and custody, or an action for legitimation and visitation. So those can be part of the same case, but if it is only legitimation, it doesn't get you. So most of the time, you file a petition for legitimation and custody or legitimation and visitation. If you are seeking custody or visitation as part of the action, you would usually file a post-parenting plan with the court, telling them, roughly what's the schedule you would like, how much time would you like to spend with your child, how are you proposing that you and the child's mother divide up making legal decisions for the child. And that's just a proposal. It's telling the court, here's what I think should happen. And then once they're served with it, the child's mother has the right to file her own proposal saying, well, here's what I think should happen. And the way that that can be resolved in the end is either that the parties talk to each other or meet with a mediator and come to an agreement and put that agreement in writing saying, here's what the arrangement's going to be, here's the schedule for visitation or custody, here's how we're going to handle decisions for the child. And then that gets presented to the court as a consent order, which is basically a court order that the parties have agreed to. Once the judge signs it, it's a court order like any other, and it's enforceable, even though the parents did come up with it by themselves and agreed to it. If the parents can't agree on either some of the issues or all of the issues, even if they can't agree on anything, whatever the parents cannot agree on, the court will make a decision about. And that means that anytime after that 30-day mark passes, once the person who received the legitimation has had a chance to respond to it and file an answer if they wish, then the court can schedule a hearing. Now, the hearing is going to be either in person or on Zoom. Some counties do both. Some counties do everything in person. But the court will tell you where and when you're supposed to appear and how you're supposed to appear. And at that hearing, the father has the chance to tell the court, here's what I'm trying to establish, here's what I'm asking for. And if they are asking for a particular custody arrangement for physical or legal custody, they can explain to the court why they feel that that is in the child's best interest. Now, custody is a whole separate issue that we're not going to go deep into today, but the general standard in Georgia is that the court is going to make decisions about child custody based on what is in the child's best interest. And so that's what, if a father is coming in a legitimation case asking for custody or visitation, he should be prepared and expect to explain why what he's proposing is in the child's best interest. And then the mother has the chance to respond and say, well, here's what I think is in the child's best interest. Now that standard applies both to legitimation, whether the child is made the legal child of that parent, and to custody. But as I said, those are two separate steps. And the court has different standards for how they approach each of those. When it comes to legitimation, and legitimation itself does not give the custody rights, it just says this man is the legal father of this child. In most cases, the court is going to grant legitimation once the court is satisfied that that is in fact the child's father, whether they require a paternity test or not. Most of the time, the court is going to feel that it is in a child's best interest almost all the time to have both their parents legally established as their parents, to know who their parents are legally, and to have the right to inherit from each of them or receive public benefits on either of their behalf. When I'm advising either mothers or fathers about this, I tell them, whether or not it makes sense for someone to be involved as a custodian to a child, it is usually in that child's best interest to, have a legal tie to both their parents. And, if something were to happen to the father, that they can then receive Social Security survivor benefits. If their father has access to any other benefits that, are accessible to their dependents, it's good to have them legally established as a dependent. So most of the time, the court is going to grant legitimation unless there is a very compelling reason that it is not in the child's best interest to have their father legally established as such. One thing that can come up in that setting is whether the father has, they call it waiving an opportunity interest, but basically whether the father has declined to have a relationship with the child for a long time, that the court views it as almost too late to come in and establish that legal relationship. Sometimes this will come up if you have someone seeking to legitimate a child when that child's older, when that child is, 10 or 12. Now, sometimes this comes up because the mother and father have had an amicable, workable co-parenting relationship for years, and the father's been around, been involved, and then that relationship falls apart. And the father then files for legitimation because they're being denied access to the child. In that case, the court is going to look at the facts and say, oh, this is someone who has been involved, who's been acting as the child's father their whole life. The child knows them as their father. It's in the child's best interest to have this person legally established as their father because they've been that in every sense their whole life. On the other hand, if you have someone who has a child and files to legitimate that child 10 years later, and they have not had involvement in the child's life, they haven't had a relationship with the child, they haven't really been in the picture, in some cases, the court may find that that person has sort of slept on that right and, not taken up that relationship with the child for so long that it is not in the child's best interest to legally establish the relationship. A lot of the time, this comes up in the very specific situation where you have someone else who's looking to step into a parental role for that child, like a step parent. And so all of a sudden, the biological father decides, oh, I want to jump back in, I want to get involved. And if there is someone else who is wanting to step into that role and who has, shown their willingness and ability to be in that role, and the father hasn't, that is one situation where the court sometimes will deny legitimation. Most of the time, though, legitimation is not denied if there's not someone else who's looking to step into that role and to be a father to that child. Then, as I said, legitimation is the first step, custody is the second step. So it is possible for the court to grant legitimation and say it's the best thing for this child to have a legal father and have a legal relationship to their father. But whether it's best for that father to have custody or visitation is a whole separate decision. So once they've established legitimation, then they start looking at what is in the child's best interest as far as custody. Child support is a whole third step. So as I mentioned previously, the big things to keep in mind here are, first, a father can be ordered to pay child support without having been legitimated and having legal standing in regard to that child. So if you have unmarried parents and the mother files for child support, the father can be ordered to pay whether or not he goes through the steps of legitimating. Conversely, just legitimating a child does not create a child support order. Very often, a child support order becomes part of the situation because often when the father files for legitimation, the mother will then counterclaim and ask for the court to order child support. So often they end up going together, but they don't have to. You can be legitimated without being ordered to pay support. You can be ordered to pay support without being legitimated. But that's something to be aware that it can come up as part of the process. So how legitimation interacts with child support is that, if you file your legitimation action, say you're seeking to legitimate a child, you file an action against that child's mother, she files a counterclaim saying, I agree to the legitimation or I don't agree to the legitimation, whichever she feels. She can also ask the court to order child support as part of the final order. And, while certainly you can respond in terms of how much that child support should be, or, what the court should consider your earnings to be, it's very likely that you would be ordered to pay support at that time. So before we move on to the next section, do we have any questions that have come up in the chat while we've been going so far? Because I realize this is a lot of information. All right, great. So if questions come up, please feel free to put them in the chat and they'll be passed along to me. So one thing that comes up a lot is at Legal Aid is that fathers will contact us looking for assistance with legitimation. We also get contact sometimes from mothers asking, how do I establish someone as my child's legal father? Now, the short answer is that a mother cannot file a legitimation. The only person who can file legitimation is the father on their own behalf, saying, I want to be established as this child's legal father. However, there are other things that a mother can file. The main one is called a petition to establish paternity. You can also, and that forms a similar it serves a similar legal need as a legitimation in saying, having the court acknowledge that this person is the child's father. But only the father can assert the right for legitimation. Really what you would want to do in that situation, if you are the mother, depends on what your goals are. If your goal is to have the child established as the father's child so that they can receive benefits, for instance, if the father receives disability and you'd like the child to receive dependent benefits, if the father is a military service member and you'd like them to be able to receive benefits through that or through the VA, establishment of paternity could meet that need in terms of having a court order saying this person is the father that would benefit the child, but doesn't necessarily do anything to benefit the dad. So if there's a situation where, you are the mother and you're looking to in some way establish someone's paternity for whatever purpose, that's a situation where you would probably want to speak to a lawyer and figure out what your best options were, whether that's a child support action or a motion to establish paternity, or whether if you have a relationship with the father, you can urge him about filing legitimation, and that would serve the same needs as well. One thing that comes up sometimes in legitimation as well is, oh, and I see we have a question in the chat box, so I'm going to go to that before I move along. What documents are needed to file legitimation? So the main document, sort of the heart of the documents that you're filing with the court, is the petition or complaint for legitimation. And that is the document where you're laying out to the court, here's who I am, here's who this child is and who their mother is. Here is how she can be served with this notice. And you're telling the court, I want to be legally established as this child's father so that they're my legal heir. They can inherit from me and, they can receive any benefits on my behalf and so on. So that's the main document that you're filing, which generally you'd have to have verified before a notary. And that's the main document that's telling the court what you want. There are a lot of other documents that you will file along with it, just to establish the case. And many of these would get filed in any family law case. The first is a standing order. Each county in Georgia has some version of a standing order that goes into effect anytime you file a family law case, and it kind of lays out the ground rules for both parties while that case is pending. For instance, it will say that neither party can take the child outside the state, outside of the court's jurisdiction, until the case is finalized. It will say that neither person can go around harassing or speaking ill of the other person or, intimidating them while the case is pending. In cases like divorces, it will say that neither person can clear out bank accounts or transfer assets. That doesn't apply in this case, but it's the same kind of order for any family law case. So that family law standing order would be filed with a petition for legitimation. You would also file the summons, which is the document that gets served on the other party and tells them where and when they can file an answer. Generally, it's going to say you have 30 days from the day you're served, and it will provide the address, either of the person who filed the case or if they're a lawyer, if they have one, so that the respondent, the mother, knows where to send the answer. Each county court system is going to have some sort of case initiation form that just says, what kind of case it is and who the parties are, and provides contact information for them. So that might vary a little bit from county to county, but usually there's going to be some sort of case initiation form like that. In many cases, you may end up needing to file a domestic relations financial affidavit. If there's any financial issue in the case, either because one side is seeking child support, or if you're asking the court to waive the filing fee in the case, in many cases, you'd be required to file an affidavit that goes into your income and expenses. You'll file a certificate of service if you're asking the court to, or rather a sheriff's entry of service form, if you're asking the court to have the respondent served by the local sheriff, you'll file that, and then it's sent along to the civil process unit of the sheriff's office. I believe I'm hitting all the big ones there, but if you go to either the legal resources we're going to provide at the end of the session today, the websites that have the form packets for this kind of case, or if you are in a county that has a family law information center, those are places you can go to make sure that you have all of the forms necessary in your county, because those things might vary slightly county to county in terms of what's required. Another situation that comes up at legal aid with people contacting us about legitimation is, sometimes it's the father contacting us wanting to legitimate, sometimes it's the mother contacting us to either respond to a legitimation or asking how to establish their child's legal father. Sometimes we get contact from third parties, like grandparents or other relatives who are interested in filing legitimation basically on behalf of the child's father. The short answer here is that that's not a thing. The only person who can file a legitimation is the father who's seeking to be established as a father. Now, it does happen that sometimes it is the grandparents or some other relative who is sort of had the idea and wanted to establish that legal relationship. And it's true that by establishing that someone is a child's legal father, that then, documents their relationships with the rest of that person's family. Now, that in itself does not give the grandparents, aunts, uncles any particular rights, but understandably, if you're a grandparent or other relative and you want to be sure that that relationship is preserved, then making sure that that child's father, if that person is your child or your relative, making sure that they assert their rights through legitimation may be one way to get that done. So if you are a third party who's interested in this, where you're not actually the father or the mother of the child, you'll want to speak to, the parents and, go through them in terms of legitimation. They're the people who are going to be either filing or responding to those cases. So trying to think if there's anything I have missed here or any questions we need to go into. And there's a lot of information here. So I am going to point you all in the direction of some of our online resources because, this is a lot of information to hold on to, and it's good to know where you can find it in writing. GeorgiaLegalAid.org is a website maintained by Atlanta Legal Aid, and it provides general legal information that's going to be applicable around the state. Now, the state law is the same no matter what county you're in, so the same law is going to be applied whether you're in Metro Atlanta or across the state from here, but different courts might have slightly different local procedures. So if you look at that GeorgiaLegalAid.org website, that information is going to be applicable from a legal standpoint, and then you'll want to talk to people in your local court about the specifics of filing there. On that website, we have links to the forms you would need to file a legitimation, some documents that go through some of the same information I've shared here today about what a legitimation is and what it does. And it will include links to other local resources in different counties around the state. Many Georgia counties have something called a Family Law Information Center, which is a center within the courthouse usually, or close to the courthouse, that is open to the public, where people can make an appointment to come and meet with a lawyer and have paperwork reviewed or ask questions. Those can be a great resource if you would like to speak to an attorney or have an attorney review your paperwork, but you don't necessarily want to hire one to represent you through the whole case. Or if you want to figure out, do I need to hire an attorney? The Family Law Information Centers can be a great place to have that kind of brief consultation without committing to retain an attorney. So I saw some questions come in the chat box about what happens if you have a child who was born in Georgia and lives elsewhere now, or a child who was born somewhere else and now lives in Georgia. So this gets into an area of law called the Uniform Child Custody Jurisdiction and Enforcement Act, or UCCJEA. And that is an interstate compact between the 50 states where they basically agree about how they're going to decide which state has authority over a child's custody, over making decisions for that child. Now, the short answer is that if there has not been a custody decision made about a child ever, and they live here in Georgia, and they have lived here in Georgia for at least 6 months, then Georgia law is what's going to apply. Because generally speaking, in order to establish, a place as the child's home state, once they have lived there for 6 months, that state is going to be considered their home state, and that state's law is going to apply. So that can mean that if you have a child born in a different state, maybe in that state, their father's name being on the birth certificate was enough. And if they were in that state, their parents would be considered to have equal legal rights, equal legal standing. But if that child has moved to Georgia and has now lived in Georgia for more than 6 months, and there is not a prior court order from some other state about who has custody, who has parental rights, then Georgia law is going to apply. So unless there's a court order saying otherwise, the mother is going to be the sole custodian, the sole legal parent of a child who was born out of state and, to unmarried parents, and the father has not legitimated. The flip side of that is that if you do have, let's say that your child is born in another state and a custody order was entered in that state, even if the father did not go through anything like a legitimation process, maybe that state doesn't have legitimation, but you do have a custody order saying who has physical and legal custody. That order is going to be enforceable by whatever state that child lives in. It can also be modified if another state finds that there's reason to modify it. But if you have a court order from another state, that's going to be the law that controls, who has custody of a child. If you don't have a court order and the parents are unmarried and the child's home state is Georgia, Georgia law will apply. So the father would need to legitimate, even if he doesn't live in Georgia. If the child lives in Georgia, that's the law that's going to apply. Now, if you have a child who's born in Georgia, let's say that you have unmarried parents who have a child here in Georgia. Father is not legitimated, so under Georgia law, he does not have standing as the child's parent. Maybe the child moves somewhere else with their mother or with their father, and that state has different rules. Once the child has lived there for more than 6 months, that state's laws are going to apply. So you're going to want to look at what the paternity laws are there. It may be that if the father's on the birth certificate, that's enough. But once the child has established that other place is their home state, Georgia law is not going to be the relevant law there. Let's see, do we have any other questions before we start talking about some legal resources that you all can look to or wrapping it up? All right, so I'm going to tell you about, I mentioned the Family Law Information Centers and Georgia Legal Aid as georgialegalaid.org as a great website to find any information you might need from around the state. Any of those forms that say a particular county on them, at the top, they might say Superior Court of DeKalb County, Superior Court of Gwinnett County. The forms are going to be applicable across the state. So if you're using them in a county other than what it says, you can use whiteout or cross it out, right in the name of the county you're using. The forms are going to be generally applicable across the board. Like I said, there might be minor procedural differences from county to county in how things are filed. And that's something you'll want to speak with the local court about and make sure that you have accurate information about that. I apologize, there's a helicopter or something, it's very loud. So if you are within the 5 metro Atlanta counties that we serve here with Atlanta Legal Aid, that is DeKalb, Fulton, Gwinnett, Cobb, and Clayton counties, or if you believe you have a case that should be filed in one of those counties, regardless of where you live, if you're a father and you're looking to file a legitimation where the mother lives in one of those 5 counties, you can always contact Atlanta Legal Aid for advice about how to proceed. And if you are not within our practice area, we can potentially give you, if you live here in our practice area and you need to file a case outside of it, we can give you referrals for where you might be able to get assistance on that. We have offices in each of those 5 counties I named: Gwinnett, Cobb, Clayton, DeKalb, and Fulton. And we have a number of special units as well as our general county offices around the metro area. The phone number for our main downtown office in Fulton County is 404-524-5811. And even if you're located in outlying county, if you call that number, we can make sure that you're sent to the right place or to the right program to serve you within Atlanta Legal Aid. Our website also has a lot of resources and contact information for our different programs, and that is at atlantalegalaid.org. So that is a great resource both for this issue and for many other legal needs you might have. And if you have any other questions or would like more information about any of our practice areas, feel free to reach out. It's been a pleasure talking with you, and feel free to reach out to us if you have any questions or legal needs.